Proceed.
All right. We are now ready for the state's rebuttal proof, if I understand correctly. Is there anything we need to take up before we bring the jury in?
Judge, do you want us to do a jury out with photos?
All right. Let's go ahead and do that so that we can be clear on what is going to be admitted and what is not. All right, I believe you're going to call your next witness in order to introduce these photographs or at least demonstrate them.
State call for Joseph Calhoun.
Stand right here, face the clerk, raise your right hand, be sworn.
Do you solemnly swear or affirm that the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good afternoon. Will you state your full name, please?
Deputy Joseph Calhoun,
Thank you. And spell your last name?
Calhoun.
Thank you. And Deputy Calhoun, you are employed by the Dixon County Sheriff's Office.
I am.
And what's your position there?
I'm a Special Services Division deputy.
Thank you. And in your position, have you, on certain occasions, encountered and interacted with the defendant?
I have.
And do you see the defendant, Stephen Wiggins, in the courtroom today?
Yes, I do.
And can you identify him for us, please?
Sitting there with a plaid shirt.
Thank you. And what are your interactions with the defendant over the last 2.5 years?
In conjunction with Tennessee Highway Patrol, we transport him to and from each court date, dress him in street clothes, and then back into his jail attire.
Thank you. And when in the transporting of him without a shirt on,
Yes.
and why would that be?
The transition from the jail clothes to street clothes.
Okay. And over the last 2.5 years, have you observed that the defendant has received some new tattoos?
I have.
Okay. May I approach the witness, Your Honor?
You may.
Deputy, can you identify this photograph for us?
Yes.
Other one. And what's the photograph?
It's a tattoo on his right side.
And what does the tattoo say, the text? And you
Ain't
can-
got no time for that, death row.
Ain't got no time for that, death row,
And hellbound.
and hellbound. Now, when you first came into contact with the defendant 2.5, 3 years ago, did he have this tattoo?
No.
So did he get this tattoo after being incarcerated at the Robertson County Jail?
Yes, he did.
And you know that by how?
The numerous court appearances from the time he was brought to Robertson County and to December of 2019 when we observed the tattoo on his side.
So you observed this tattoo in December of 2019?
Yes.
All right. I'll make that the next exhibit, please.
All right, we're going to mark it as an exhibit for the purposes of this hearing and for identification only. So this would be C, identification.
Yes, sir.
And Deputy, can you identify this photograph?
Yes, I can. It's a tattoo on Mr. Wiggins' back.
And can you describe for us what the wording at the bottom of the tattoo says?
It says, "Crush your enemies, show no mercy."
And is that tattoo new? And when I say new, did it occur after he was arrested on this homicide case?
Yes,
And it occurred sometime while he was being held in the Robertson County Jail?
yes,
And you observed it, again, as you described, in the transporting back and forth to court?
yes. On also on December when we did seen the tattoo on his side.
Thank you. That'd be my questions, House Wiggins.
All right.
I'll move that photograph as Exhibit 2 for the purposes of this
Exhibit
hearing.
D for identification. Defense have any questions?
Yes, Your Honor. Deputy Calhoun, how are you?
Doing fine, sir.
All right. So I just want to be clear on a couple of things on timing. So it's my understanding you're not relying on earlier photographs of Mr. Wiggins. You're just saying from your memory of him 2.5, 3 years ago?
No. Every time any Dixon County Sheriff's Office employees are alone with Mr. Wiggins, just to make sure there are no allegations made, we use body camera to record, to make sure there's
Okay.
no allegations made against us.
Okay. And did you review like body camera footage before you testified today to say back when?
Now, I do remember that it was in December. I did not remember about the back tattoos, or
Okay.
the lower tattoo.
Okay. And which one is when you say the lower tattoo, is it?
The part where "Crush your enemies, no mercy."
Okay. And that's something you had to go back and refresh your memory about looking at body cam videos?
Yes, sir.
Okay. And did you go back and look at body cam videos from before Mr. Wiggins went into Robertson County?
Yes.
And am I to understand that on those on that footage, you were not able to see these tattoos on him?
No, sir.
Okay. But you can't say other than one day he had them and one day he didn't. You don't know how or when he got them or who gave them to him.
No, it was somewhere in between April of 2019 and December of 2019.
Okay. Don't know where
No, sir.
or how
No, sir.
or who.
No, sir.
Okay.
Well, I take that back. So when I asked Mr. Wiggins about the tattoo, because even that day he had mentioned the tattoo on his forearm, his right forearm, about getting it while there. And when I asked him about it, because we took a picture with a cell phone camera, I asked him when did he get the tattoo. He said when they put my tattoo artist in my cell with me.
Okay. But that was the one on his arm.
No, that was the one on his side.
Oh, you asked him specifically about that one?
Yes.
How'd you know to ask him about that one if he had a shirt on?
Well, at that time he did not have it on. My partner come in and took a photo of
Okay.
the tattoo.
Understand. Thank you.
Right. You wish to argue this introduction of this evidence?
Just briefly, Judge. One, the defense's final two witnesses of the mitigation phase were two employees of the Robertson County Jail who both testified that the inmate was compliant and violated zero rules. Two, the state's first witness in our rebuttal phase is the administrator of the jail, which testified just the opposite of that he did commit infractions and violations by getting tattoos in the jail. Also, one of the mitigating factors that the defense has requested goes directly to this, and it's a broadly captioned, and it's the final one that says, but any factor that would allow the jury to extend mercy to the defendant. Well, the defendant doesn't want mercy, and it's clear from that because after this homicide occurred, he got a tattoo. No mercy. I mean, it's obvious from this tattoo goes directly to this mitigating factor.
Mr. Evans?
So, one, we've never seen any body cam footage and haven't been provided any body cam footage that would corroborate this officer saying that whether the timing of these tattoos. So, that's one issue with the tattoos. The second is this doesn't go to rebut any mitigating circumstance and showing the tattoos. If they want to say, arguably, that this was a violation of the rule, which is in evidence, that there was a rule and he got tattoos, That's what rebuts what was in evidence. And both of those individuals that testified in our proof talked about Mr. Wiggins. I think one said he was a model inmate, and one said he doesn't give us no trouble. He does exactly what we tell him to do. That has in no way opened the door to showing these tattoos, both of which have very little probative value to the issue, which is whether he followed the rules. He got tattoos. It's in evidence. To go in and put a picture of a tattoo into evidence and allow this jury to see something that says death row is absolutely prejudicial and has no probative value. Second, show no mercy. Again, it's not proper rebuttal evidence. It's extremely prejudicial because that's the province of the jury, is to decide whether they want to show mercy. And this idea of death row, we've been prohibited from going into talking about the punishment. And now they're wanting to put tattoos in to say that the defendant is somehow given some kind of preference on punishment by saying death row. And what did he just say? He's asking for no mercy. Your Honor, it's improper. It would be unduly prejudicial. Has no probative value. We'd ask that it be excluded.
Judge May, I'll be heard. Again, Your Honor, we haven't received the final structure of the mitigating factors, but the way the defense has proposed them, half of their factors are specifically, not half, but several of their factors are specifically engaging the jury with coining the term life without parole. But beyond that, let's go through kind of the summation of what the defense is asking the jury to consider as mitigating factors, regardless of how the defense actually worded them. One, proof put forth by 5 witnesses, expert witnesses talking about neurology and images of the brain, that when combining their testimony are all asking the jury to understand that he didn't have the ability to control his impulses. Well, he does, and these photos go to that. I mean, you know what you're doing when you're getting a tattoo, multiple tattoos. Now, it might be one thing if somebody is impaired or drunk and runs out one night on the town and gets a tattoo. Maybe that was impulsive. But when you're sitting in the jail and have to use a homemade tattoo gun, that is showing your ability to control your impulse. And secondly, you don't just have an impulse to get a no mercy tattoo when you're facing capital punishment. When you're facing death row, you don't impulsively get a death row tattoo. This goes directly to the heart of the defense's mitigation. Second, experts concluded that his behavior and life in jail is Stephen's best life. Quote, best life, controlled behavior, impulse control, and living a good life will happen in confinement. That's a mitigator they're putting forth. Okay, so his best life in jail, he decides to get a tattoo that says, show no mercy. Well, he didn't show any to Sergeant Baker. We know that. He gets a tattoo in death row while living his best medicated life. Because that's also an argument of the defense as mitigated, is now that he's on these psychotic medications, he's living his best life. And under a best life scenario, he still makes the decision to get a death row tattoo. 3, they've argued continuously from the beginning of this trial, starting with jury selection, to show my client mercy, show my client mercy. And I have a video clip from the opening statement of the defense's rebuttal, Mr. Etheridge, where Mr. Hopkins specifically uses the word mercy twice. Please play the video.
Judge, I just want to say, I don't know that that's necessary. Our opening statements aren't proof. I don't even know that that's a determining factor.
I remember the opening statement. I'll acknowledge on the record that he did use the word mercy throughout his closing argument.
4, they have introduced a letter to this jury as an exhibit that was written to me from defense counsel, signed by Mr. Wiggins, stating that he will plead to life without parole. Well, that's because, as the tattoo says, he doesn't have time for death row. This goes directly to rebut that letter that was written to me and signed by the defendant. How else do you rebut that letter? Now, I had already asked Mr. Evans to have a jury out before that letter was introduced, and I'm not alleging anything nefarious here. It was an accident on their part. But Mr. Hopkins told the jury that they were going to introduce. that they wrote a letter to me asking for life without parole, not knowing that Mr. Evans and I had agreed to have a jury out. Nonetheless, he said it and they introduced it. 4, we have seen multiple email messages and phone calls between the defendant and his mother, and including Spencer, his son, talking about their affection for each other. One of their mitigating factors is that Mr. Wiggins now has this enduring love. Really? Well, are you teaching your son to show no mercy, have no compassion, ain't got time for death row? 4, there's a letter from Mr. Wiggins' son, or from his son. That factor actually, these photos don't go to that. There's numerous other things, but in a nutshell, Your Honor, these photos go directly to the heart of every mitigation listed in how they're structured currently in the form the defense has provided them.
Well, number one, these photographs have been considered by the court, and I think they were tendered at an earlier stage of this trial or this hearing. The defendant has submitted a number of mitigating factors which they asked the court to include in its charge, and of course the court is required by law to charge the statutory language of mitigation, which the only statutory mitigating factor that I find, it appears to me, there are only 2. One was that the murder that could possibly apply, I'm not saying they do, but they could possibly apply, was that the murder was committed while the defendant was under the influence of extreme mental or emotional disturbance. I think it doesn't rise to the level of a defense, but that may be one of the things. The other was the statutory language, the capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was substantially impaired as a result of mental disease or defect or intoxication, which was insufficient to establish a defense to the crime, but which substantially affected his judgment. Throughout this hearing on the mitigation phase, there have been numerous expert witnesses who have testified about the mental capacity, his impulsive nature, his inability to control his decisions, and so forth. The question about mercy is not necessarily one that the court is required to charge, nor will I consider mercy as an aggravating or as a mitigating factor. I don't think that's something that under the law and the case law, as I read it, is necessary to be charged. But even with the rewording of the mitigations that are sought by the defendant, they've produced proof to indicate that he's been a model inmate, and they allege that he has not committed any acts of violence towards inmates and the staff in jail, that he has done good and selfless acts in his life and is loved by others, that his mother and his aunt and his 10-year-old son love him. All of those go to the character of this defendant, and all of those are rebutted by evidence of these tattoos, which indicate that while it may be said he has not committed any acts of violence, the tattoo on his back that indicates to crush his enemies and show no mercy does tend to me to go to a potential violent nature that would rebut the type of evidence that's being offered in mitigation. In addition, that evidence would also go to the fact that he's being portrayed as being someone who is a loving son, and I think that under the circumstances as I see them and the evidence that's before this court in the mitigation phase, that there is probably there is enough evidence in the mitigation phase that would justify the state to introduce these photographs for the purposes of rebuttal of that. In addition to that, one of the things that they do submit is that the defendant offered to plead guilty and receive a sentence of life without the possibility of parole or release, which is essentially a plea for mercy, even though it's not termed as such. And under those circumstances, the tattoo and the tattoo on his back and the tattoo on his side would indicate to me that that would be sufficient rebuttal. So even though the defense objects to those, I believe they are relevant, I believe they are admissible and on the issue of rebuttal of the mitigation factors, and therefore they will be allowed to be presented to the jury. All right, then anything else before we bring the jury in? And so that I can make sure that the record is clear, Ms. Jones was reminding me, I have found that, and do find, that the probative value of these, on those issues, on those factors, that the probative value of those photographs outweighs any prejudicial effect. More particularly, that this defendant was charged with first-degree murder and was awaiting trial when those, for knowing that the death penalty was something that was being sought. So again, it goes to the issue of his decision-making process, which according to many of the experts was that he was mentally disabled in some way, that he has organic brain damage which has been untreated, and that he has been treated with antipsychotic medication, anti-seizure medication in jail to successfully manage day-to-day. That's a factor I failed to mention, and that factor alone seems to me to be rebutted by the evidence of that type of photograph of those tattoos. So I do find that the probative value as to rebut those mitigating factors is resulting. So that's the decision of the court. Anything before then, we bring the jury back. I'll bring the jury in. Those have been marked as exhibit for identification purposes when you present your proof. We'll need to go through the introducing them as an exhibit. Who was it? So, you can say that again. Yes, sorry. All right, we have everyone back. Thank you, ladies and gentlemen. Let me explain to you that, again, in your absence in a procedural matter, I had this witness was placed under oath, and his testimony will be sworn under oath. So, General Crouch, you may present your witness.
We state your full name for the court.
Deputy Joseph Calhoun,
Thank you. And would you again spell your last name?
Calhoun.
Thank you. And Deputy Calhoun, where are you employed?
Dixon County Sheriff's Office, Special Services Division.
Thank you. And what does your job entail in the Special Services Division?
So I do criminal warrants. I also do high-profile court transports and death penalty trial transports.
Okay. And over the course of the last almost 3 years, have you been charged with transporting the defendant
Yes, sir, multiple times.
from Robertson County to Dixon County?
Yes, sir.
And is that for purposes of going to court appearances?
Yes, sir.
Okay. And in doing so, what processes do you go through in interactions with the defendant?
So the Tennessee Highway Patrol typically actually does the transport. So the defendant was riding with them. But our responsibilities were we would put on leg shackles, handcuffs, belly chain, and then once getting him to our court, we would then remove those items and dress him from jail attire to street attire.
Okay. And in doing so, did you notice that the defendant had gotten some new tattoos?
Yes, sir. December of 2019, we had noticed that he had a new tattoo on the right side of his rib cage.
Okay. A tattoo that had not previously been there?
No.
And how do you know that it had not previously been there?
Every time we are alone with the one or two of us of DCSO personnel, just to make sure there are no allegations made, we use a body camera. And the body camera rolls the entire time we are in the cell with him. And the body camera documented the let's see, it was April of 2019 was one of his last court dates. It did not have it in there on his rib cage.
So let me stop you. In April of 2019, there was no tattoo.
Nope.
And then you came back on a later date?
Yeah, in December of 2019, when he come back for another court date, we noticed the tattoo.
Okay. So sometime between April of 2019 and December of 2019, the defendant got the tattoo.
Yes.
All right, may I approach the witness?
You may.
Deputy, can you identify this photograph?
Yes, this is the tattoo we observed on Mr. Wiggins' right side of his rib cage.
Okay. And is the photograph you're holding the same photograph that we see displayed on the screen?
Yes, it is.
And can you describe the text of the tattoo, please?
It says, "Ain't got no time for that, death row," and it says "hellbound."
Okay. And was this entire tattoo new when you saw it in December of 2019?
Yes,
And when I say new, it wasn't there in April of 2019?
correct. It already healed. It was not red. It was like it was a fresh tattoo.
Did you talk to the defendant about this tattoo?
Yes, we asked him when my partner come in to take a picture of the tattoo. Mr. Wiggins inquired as to why we were doing that, and I told him because it's a new tattoo. Mr. Wiggins said, "What about my other new tattoos?" And then I asked him, "When did you get this tattoo?" And he said, "When they put my tattoo artist in my jail cell with me."
Thank you. I'll move that as the next exhibit, please.
That would be Exhibit
279.
279.
And Deputy, can you identify this photograph?
It's a tattoo on his lower back.
Okay. And when did you observe, or approximately when did you observe this tattoo?
I observed this one on the same day.
On the same day? And was that a new tattoo?
To my knowledge, yes.
Okay. Again, do you think it appeared sometime between April of 2019 and December of 2019?
I believe it did, yes.
Okay, so it was, he received this tattoo while pending trial, is that correct?
Correct.
And while being held in the Robertson County Jail.
Yes.
And can you read the text of this tattoo?
It says, "Crush your enemies, show no mercy."
And did you have any discussions with the defendant about this tattoo?
Not this particular one, no.
All right, I'll move that as the next exhibit.
Mark is 280.
I'll pass the witness.
Any questions?
No question.
Thank you, officer. You may step down. State may call your next witness.
Your Honor, state to call Deputy Paul Miller, Davidson County Sheriff's Office.
You would stand right here, face the clerk, raise your right hand, please.
Do you solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Have a seat in the chair, speak directly to him.
David, push your arm.
All right.
Got a call. This jailer, in regards to remarks he made specifically about Sergeant Baker, soon after the crime happened. In the issue, as you can see about the middle of the page on that paragraph where he makes two different remarks. Those reportable.
Let me read this. Let me step back. Let me read it first and then. You've been sitting quite a while. I'm going to ask you to get up and walk across the hall, please. All right, Mr. White, you want to tell me what the relevance is of this particular piece of documentation in this witness's testimony?
Yes, Your Honor. Your Honor, in particular, the statements that the defendant made to Deputy Miller, one, rebut the statements that were in the MTMHI intake report where he told the physician there that he was trying to do suicide by cop. Second, this goes to the mitigating factor.
Excuse me, but repeat that part. You're just saying it goes to what?
To rebut the defendant's statements that were put in by the defense for as far as his mental health goes, where he stated that he was trying to, when everything happened with Sergeant Baker, he intended it to be suicide by cop.
All right.
Next, Your Honor, this goes directly to mitigating factor number 8, as it is in the statute, the capacity of the defendant to appreciate the wrongfulness of the defendant's conduct or to conform the defendant's conduct to the requirements of the law was substantially impaired as a result of mental disease or defect or intoxication, which was insufficient to establish a defense to the crime, but which substantially affected the defendant's judgment. These statements directly rebut that mitigating factor, which was essentially the bulk of the defense's mitigation proof. This goes to the last two witnesses the defense put on about the model inmate situation. This also goes to rebut the character of the defendant that has been put at issue, the loving son, nephew, father character that has been put at issue. And it rebuts directly to those factors.
Your Honor, respectfully, it doesn't rebut anything that we put on in mitigation. This statement, number one, is not proper rebuttal under any indication. If they wanted to put this statement in, their time to do that was prior to now. This is not a catch-all time for them to come in and pile on all the things they didn't put on first, or they didn't think to put on first, or maybe they strategically chose not to put on first. But this statement goes to the offense itself. Not one time in our mitigation proof did we ever suggest what he was that the crime didn't occur as they said it happened. And there's been no proof otherwise. And when you talk about, I've been reading through our mitigators, I don't see in our mitigators that we listed out and sent that we proved that number one, that was number 8. I know it's a statutory mitigator, but we're talking about the proof we put on in mitigation. We put on that, and even if it were, and we consider it as a statutory mitigator, this statement doesn't go to that. And we talk about what he said to the MTMHI doctor. This statement doesn't rebut that. His feelings about the crime, we went at no time went into that mitigation. At no time. and that one statement saying he intended it to be suicide by a cop, this doesn't rebut that. Those two could be mutually exclusive. So it's not rebuttal. And if it's not rebuttal, it's not appropriate, number one, and it's highly prejudicial at this point to put this in. But again, it's not proper rebuttal. We would ask Your Honor not to allow it. And one more point. It doesn't have anything to do with model inmate. I forgot that one. This statement has nothing to do with it. Again, we said he had not been violent with staff. Their words were model inmate. The statement doesn't go to whether he's a model inmate or not.
Anything further, Mr. Wyatt?
Your Honor, specifically, I mentioned number 8, relying on State versus Hodges, which says that it is improper for the court to charge specific mitigating circumstances. And so with that in mind, I'm taking the bulk of their mitigating circumstances and condensing it down to number 8, which is ultimately what they're getting at, which is what this rebuts.
All right, I'm going to take a recess. I'd like to see all of the reports from the mental health experts that were made exhibits. If you will pull those and hand them to my law clerk, then I will take a minute. Ladies and gentlemen, this may take some while. So that the record is clear, this is a document that is proposed to be introduced, generated at the Davidson County Sheriff's Office, a sensitive access incident report dated August 24th, 2018. And I'll not go into the specifics of it, but it contains information that the state wants to have the jury review that I have to determine whether or not that would or would not be admissible as rebuttal proof to any of the state's the defense's mitigation proof. So that will take some time to do it. I'll move as quickly as I can and give you an answer. So.
Judge, just so Your Honor knows, our next witness, excluding the one on the stand now, would be Agent Nathan Neese, and we're going to be moving in the jail call that the court has already previously heard. So if you want to...
The jail call regarding what?
The jail call in which the defendant tells the son to kick the pregnant mother in the stomach. That would be what we intend to move through Nathan Neese, and then after that we'll be calling our rebuttal expert. So we still plan to finish our proof tonight.
Understand.
Thank you.
All right. We will address those issues. Deputy Miller, you might want to stand down from the stand until I get back. So. Yes, sir.
All rise. Court is recessed.